So I'm going to turn it over on the next slide to Ben Dryden to talk about how we got here.
Thank you, David, and thank you everyone for joining today. If you are wondering who is the Federal Trade Commission, what are they doing regulating labor and employment, I wanted to just give a little background on who they are, and then we'll jump into the history and provide some context. So the Federal Trade Commission is a federal agency. It's based in a beautiful neoclassical building in Washington, D.C. It's got about 1,100 employees, but the core of the Federal Trade Commission is a commission. There are 5 commissioners, of whom no more than 3 may be from the same political party. So there's currently 3 Democratic commissioners and 2 Republican commissioners. But the FTC, along with the Department of Justice, state attorneys general, private plaintiffs, the FTC has antitrust enforcement power, and it has a number of responsibilities as an agency, and those responsibilities have grown over time. So the FTC is responsible for, among other things, children's online privacy and horse racing safety, but really their core traditional responsibilities are twofold: preventing unfair methods of competition and preventing unfair or deceptive acts or practices. And I'm going to use both of those terms a lot, so I'll go ahead and define them with acronyms. Unfair methods of competition are UMCs. Unfair or deceptive acts or practices, I'm going to call UDAPs. And picture a Venn diagram. You know, any given piece of business conduct could fall outside or within the scope of the Venn diagram, but a unfair method of competition might be within the intersect of the 2 circles. An unfair method of competition might also be a UDAP, but something can be a UMC without also being a UDAP. Conversely, something could be a UDAP without also being a UMC. To put a little bit of precision around what these mean, because they are inherently fuzzy terms, an unfair method of competition is something that sounds in antitrust. So conduct that violates the antitrust laws is per se an unfair method of competition for purposes of the Federal Trade Commission Act, but the power is broader and they can reach things that aren't necessarily antitrust violations. UDAPs, unfair deceptive acts or practices, those are things that really sound in consumer protection. So it's consumer protection, it's promoting competition. Those are the 2 fundamental mandates of the FTC. And if you ever have a chance to come to Washington and walk past the Federal Trade Commission building, it's right on Pennsylvania Avenue, you'll see a gigantic sculpture, and I've got the sculpture here. It's called Man Controlling Trade. And it's this beautiful sculpture from the 40s, and it really speaks to the province and the responsibility of the Federal Trade Commission to regulate trade and commerce. Next slide. So the Federal Trade Commission was founded in 1914, and for its first 50 some odd years, it enforced its UMC and its UDAP power on a case-by-case enforcement basis. They would see something out in the marketplace that they thought was a UMC or a UDAP, and they would sue them. Starting in the early 1960s, however, the FTC started to recognize that there's a provision in the FTC Act, Section 6G, that gives the FTC the power to make rules and regulations for the purpose of carrying out the provisions of the subchapter. And so the FTC latched onto this and started adopting really a litany of substantive rules that were meant to define with specificity in particular contexts what sorts of practices or methods would constitute UDAPs or UMCs. So there were more than a couple dozen of these rules, but a couple examples are the octane rule. The FTC declared it a UDAP and a UMC for a gas station to fail to disclose the octane ratings of its gas pumps. And you think about, all right, you could see how that is deceptive to sell gasoline without disclosing what the octane is. You can see how that's an unfair method of competition. If you are making consumers think that they're getting higher quality gasoline than they might be getting across the street just through failure of disclosure. So there was the octane rule. There was the tablecloth rule that declared it a UDAP and a UMC to fail to disclose the cut and finished sizes of tablecloths. They kept going down the rabbit hole. There was a sleeping bag rule. There was a wig rule. There were a lot of these rules. Importantly, during this time, the FTC only adopted one rule on a standalone UMC basis, by which I mean a rule that they promulgated that they said certain conduct was a UMC, but they didn't also say it was a UDAP. And this was as picayune a rule as you could imagine. It was a rule requiring a written plan for disclosing promotional allowances for men's and boys' tailored clothing. The tailored clothing rule. Tailored clothing rule was never enforced. It was never litigated. And in fact, just a year after promulgating the tailored clothing rule, the FTC adopted more general advisory guidelines about disclosing promotional allowances. But those general advisory guidance were not binding. They didn't purport to have the force of law, but largely by virtue of that general advisory guidance coming out, the FTC just never had occasion to enforce or litigate the tailored clothing rule. Next slide. So this trend was in the 60s and the 70s, and eventually there was a backlash. And the chronology, it's not exactly a straight line, but one of the breaking points was in 1978, where the FTC considered a rule against television ads for sugary foods aimed at children. And in response to that, the Washington Post came out and said the FTC is acting as a national nanny. And I've got a beautiful quote in here that preventing advertisements for sugary foods is one of the roles of a governess. It's not a proper role of government. So the Washington Post was calling the FTC the national nanny. The Chamber of Commerce accused the FTC of trying to become, quote, the second most powerful legislative body in the United States. And these criticisms landed. And so Congress in 1975 passed the Magnuson-Moss Warranty and Federal Trade Commission Improvements Act, or MAGMOS, which imposed some very onerous procedures before the FTC could adopt a substantive UDAP rule. And it was meant to restrict the FTC's ability to adopt substantive rules. And then these restrictions were even strengthened in 1980. Now, importantly, we'll come back to this, but the Magnuson-Moss Act does not affect any authority of the Commission to prescribe rules and general statements of policy with respect to UMCs. That's an important caveat we're going to come back to. But historically, what happened was then there was the Reagan Revolution. The FTC had new leadership. They kind of reframed their mandate to focus on traditional antitrust and consumer protection issues. And a lot of the rules that were adopted in the 60s and 70s were then formally withdrawn by the 1990s. Next slide. But, history is a way of repeating itself, and this pendulum swings back and forth. So jump forward about 45 years later, and you start to see a renewed interest in rulemaking. And there were a few things all happening at the same time around this time. And David alluded to them at the outset. There were some really high-profile examples of non-compete agreements being used in ways that, offended the conscience. People said that this is an unfair use of non-competes, and we started to see more and more state laws trying to respond to that. And the confluence of those events meant that there were then ways for economists to try to measure the competitive effects of non-competes by seeing what was happening on a state-by-state level, what sort of legislative changes were happening, and what impacts did those have on the larger economy. So then at the same time, in 2020, a law review article was published by Rohit Chopra and Lena Khan. Chopra was at the time a commissioner in the FTC, and Lena Khan was a young incoming advisor of his. They wrote a law review article that argued that the FTC had the power to adopt UMC rules. And this article specifically gave the example about non-compete agreements. Next slide. An important detail that has been missed in a lot of the commentary is in January 2020, the FTC under Trump held a workshop examining whether there was a sufficient legal basis or empirical support to adopt some sort of a rule or policy statement or guidance about non-competes. It was an issue Trump's FTC really was looking at. And the whole project got derailed because 2 months later, COVID happened, and there were just more pressing issues. But this is an important part of the story. Next slide. I won't get political or anything, but another important part of the story is Biden made non-competes a campaign issue. He identified them in a keynote address to the Brookings Institution in 2018. And then, truly, at his very first campaign kickoff rally, he called for a ban on non-compete agreements for low-wage workers. So that this became a campaign issue. Next slide. And we all know what happened. The election happens. Biden takes office. Biden appointed Commissioner Chopra, the co-author of the paper, to serve as director of the Consumer Financial Protection Bureau, but he appointed Lina Khan to serve as the chair of the FTC. And about 3 weeks after Khan was appointed as chair, the president signed an executive order on promoting competition in the American economy. And this executive order had 72 separate subcomponents, but one of the real headline directives was directing Lina Khan as chair of the FTC to consider working with the rest of the commission to exercise the FTC's statutory rulemaking authority under the Federal Trade Commission Act to curtail the unfair use of non-compete clauses. And you could read that really as a more or less veiled allusion to that law review article. But Lina Khan, who's on the president's shoulders, he's signing the executive order, has a personal mandate from the president of the United States to at least try to get something done. Next slide. So jump forward another 18 months or so. In early 2023, the FTC brought enforcement actions against 3 companies, alleging that those 3 particular companies' uses of non-compete agreements were unfair methods of competition. One of the examples was a security guard company in Michigan that bound security guards to a 2-year, 100-mile radius non-compete, which a Michigan court had already found was unlawful under Michigan law. But notwithstanding that, the company was still requiring security guards to sign these non-competes, and it was threatening them with litigation, even though these were knowingly unenforceable non-competes. And so the FTC said that is an unfair method of competition. That's unfair. And so all 3 companies just settled by consent decree. They didn't pay a penalty or anything. We won't do it again. We'll appoint a monitor to make sure this won't happen again. So next slide. So I was even typing up a client alert thinking, okay, well, the FTC has brought specific enforcement actions against 3 companies. Might this signal that they're not actually serious about bringing a broader rule? I was typing out that client alert when the news broke on the wire. It was the very next day. The FTC came out with its proposal for a non-compete ban. And the non-compete ban, as proposed, came with a 216-page notice of proposed rulemaking, which surveyed the academic literature and made findings based on the empirical analysis that has been done that non-competes not only reduce worker wages for the workers who are subject to them, but also, this is significant, the FTC says that non-competes suppress wages for all workers, even people who aren't bound by non-competes. And they also found that non-competes raise consumer prices and increase market concentration and discourage entry by new competitors. So anyway, the FTC opened a 90-day window for public comments. 26,000 comments were submitted. And in fairness to the FTC, the vast majority of them, over 25,000 of those comments, supported a non-compete ban. Now, a lot of those were just a couple sentences. Hey, non-competes are bad. You should ban them. But, weighing the sheer number of comments, most commentators were in support of a non-compete ban. Next slide. So that brings us to where we are today, and I'll pass the baton to Russell. You're on mute.
Yeah, I even got the notice that came up. Thank you, Ben. Thank you, David. And Liz, next slide, please. Okay, so where we left off was January of 2023. We pick up now in April of 2024. So 15 months later, and the FTC, after this lengthy process, reviewing all of these 26,000, I think it was 26,813 comments, I believe. And as Ben said, so many of those comments were from individuals. They were 1-line, 2-line, non-competes bad. So the numbers certainly, I'm sure there was quite a campaign through a number of labor unions to get their members to submit comments. So you've got a lot of that going on. And obviously that took the FTC a long time to go through all of those, notwithstanding the nature of them. But there were some very, very substantive comments on both sides that were compelling on both sides. The FTC looked at all of that, and they really spent a lot of time looking at the academic literature. So When we go back to what David had mentioned earlier, with the academic literature showing that non-competes depress wages and all these kinds of things, that all started back with, well, it started actually back probably around 2009 when we started seeing that literature, but it really built, and it built upon itself to the point where by the time the FTC is issuing its notice of proposed rulemaking and then the actual rule now, there had been substantial academic literature that suggested that wages suffered from the imposition of non-competes, that innovation suffered as a consequence, that startups suffered. The problem is that there's a lot of research on the other side of that actually shows, well, wages may suffer for low-wage workers, but not necessarily for physicians or executives or others. That was primarily dismissed by the FTC. There was a lot of research that also suggests that innovation increased, dismissed by the FTC. There was some research done by one of the leading professors in this area that suggested that yes, there were fewer startups, but on the other hand, there were better quality startups. So we have fewer of them, but they're more likely to succeed. Also dismissed. So we come back to, well, what did the FTC, what conclusions did they come to? Well, they said, as you see on this slide, between $400 and $488 billion in increased wages over the next decade, averaging $524 per worker per year. That's fine. Here's the problem with that. Just going back to this academic literature and all of the support that they've relied upon, that is really varied. 15 months earlier, the number that they identified was not 400 to 480 billion over 10 years. It was 250 to 296 billion per year. No explanation for why they went from a number that was the genesis of kind of the main core of why they wanted to ban non-competes. No explanation for how that changed so dramatically, which should be a little bit alarming at that, but it is what it is. The other, they found a lot of different implications of non-competes. They were all consistent with, largely consistent, though the numbers may have varied, with the kinds of things that Ben just walked through. So I think we go to the next slide. So what does the new rule do? And by the way, the new rule, it said on the last slide, was passed by a 3-2 vote. And that's important because the 3 commissioners who voted in favor of it were Lena Khan and the other 2 Democrats. The 3 of them were on the commission at the time that the original rule the notice of proposed rulemaking was promulgated. 2 new commissioners were added, one in March and one in April. So right before this goes into place, there's not obviously a lot of time for debate or discussion about how the rule might actually be different. And the 2 Republicans that voted against it expressed reasons why they thought that the rule did not make sense. In any event, what does the rule do? Well, it largely bans all non-competes. So we're looking at, you can see the slide breaking out between over 99% of workers who will have their non-competes existing at this point, or as of the effective date, which will be September 4th. All of their non-competes will be gone. They are declared to be an unfair method of competition. Companies may no longer enter into them as of the effective date, assuming it goes into effect, no longer enforce them, and no longer tell a worker that they have a non-compete, they're subject to it. Worker is defined incredibly broadly. It is former employees, interns, volunteers, independent contractors, and sole proprietors, although really that's focused on sole proprietors dealing with other businesses or other what would otherwise be an employer. Non-compete clause, also defined very broadly. It's defined as any term or condition that prohibits, penalizes, or functions to prevent a worker from either 1, seeking or accepting a job in the United States with a different employer, or 2, operating a business in the United States after the end of employment. So a couple things to note there. Seeking or accepting a job. So we're not quite clear on what exactly that means, because you look at the terms prohibits, penalizes, or functions to prevent, and the FTC expressly rejected broader terms. They expressly rejected restrains or limits. So rather than the rule saying a non-compete is defined as any term or condition that restrains or limits, they use these other terms. So one might wonder, if you recognize that they didn't use those words and they talked about seeking or accepting a job, does that mean that, well, they have limitations on that, a limitation on the type of job might be enforceable? I think the answer to that is no, but recognize that there's still an argument around that. Then the other point, that the non-compete has to function after the employee leaves. So the FTC is not concerned with restrictions like anti-moonlighting provisions or notice provisions. That is, you've got to give a certain amount of notice before you resign. They're not concerned with that. They're really only concerned with agreements that inhibit the employee's movement afterward to certain companies, to competitors. And then there's a separate group of people that are less than 1% of workers. They've been identified as senior executives under the rule. And the senior executives are defined to be people who have officer level policy-making authority for a business entity. And that means final authority over significant organization-wide decisions, and they have to earn over or at least $151,164. And the significance of that is, who has that authority? And they've talked about in the commentary, which is a total of, with the rule, 570 pages long, and vague and yet detailed throughout, and somewhat inconsistent throughout. But in any event, they talk about CEOs and presidents and others. But it has to be, it's not just decision-making authority. It's not just the ability to recommend. It's actually the ability to make the final decision. So who really has that authority, especially in larger companies? Maybe in smaller companies, you'll see that. Next slide, please. So the rule also requires that by the effective date, I'm going to come back to that in just a moment, for any non-compete clause that is subject to the ban, you must provide notice to workers, which are current or former workers that have a non-compete clause that is still in effect. You have to tell them that it cannot be enforced and will not be enforced. There's model language. You can see it on the screen. It actually is in the rule itself. And if they're providing you with model language, you probably want to follow that, though you're not required to. You do need to send it to every worker for whom you have an address, and it can be a physical address. You can hand deliver it or mail it to them. It can be an email address, or it can be a text address, and that email address can even be their work email address. If you don't have it, okay, then the rule acknowledges that we're not going to, that's not going to be a problem if you really don't have a record of it. It must be provided in English. And you also, they've identified other languages on the website, and then you can provide a link, and that can go to, and that can provide this notice in other languages as well. But I said I wanted to come back to the effective date of the rule, of the notice, or when the notice requirement has to be, when the notice needs to be sent. The notice needs to be sent by the effective date of the rule. That's fine. That's September 4th as of right now. But if one of the courts winds up invalidating the rule, there it is subject to challenge. And if the rule is enjoined, then that's fine. You don't have to worry about September 4th. But if the rule is not enjoined, you do need to worry about September 4th, and you better have taken all the steps necessary to make sure that your notices get out by then. Next slide, please.
And while you're doing that, Russell, let me just add one point, that when we say workers, it would also presumably include ex-workers who are still within the period of their non-compete.
Yes,
so
exactly.
You've got to go back to historical workers.
Exactly right. And the rule has 3 exceptions, or at least 3 express exceptions. The first is that in the context of a bona fide sale of a business entity, and that can mean just the sale of a person's ownership interest in a business entity, or substantially all of a business entity. So that can be divisions of companies as well. If there is a bona fide sale of a business, people can have a non-compete. And the idea is that, look, you're selling something, you're getting value for it, you're making sure that whatever you've sold, you're not taking back by immediately competing with it. And that's common. Every single state that allows non-competes, and even states that don't allow non-competes for employees typically do allow sale of business non-competes. There was a change. If you're familiar with the notice of proposed rulemaking, you may remember that there was a 25% threshold. You had to own at least 25% of the stock. That is no longer the case. Just any bona fide sale. It does not apply. The rule also, the ban does not apply where a cause of action related to a non-compete clause accrued prior to the effective date. So if by September 4th, any day prior to that, you're already in the middle of litigation or a new claim arises, somebody goes out and breaches an existing non-compete, you will be able to pursue them for that. That is not what the FTC is targeting. And then they were concerned, the FTC was also concerned about First Amendment issues, that is restricting your ability to tell somebody that they have an enforceable non-compete when you believe in good faith that they do. So the FTC made an exception for that. If you believe in good faith that there is and not only is it subjective but objective good faith that somebody has a non-compete, and you tell them that you're going to enforce it, or you do enforce it, the FTC has exempted that from the ban. Next slide. As I mentioned, the rule goes into effect on September 4th. It supersedes all state laws that would otherwise permit a person to engage in conduct that is an unfair method of competition under the rule. So you could imagine where if read very broadly, as the FTC intends, that the rule could actually impact state trade secret laws, states that allow the enforcement of trade secret laws to prevent somebody from taking a job simply because they have knowledge that if they took that new job, they would necessarily or inevitably use that information. There are very few states that take that broad a view of the rule, but the FTC's rule may in fact alter that under state law. The rule also includes a severability clause. I suspect that they figured, it would be challenged, and they would like to keep whatever parts of the rule intact that they can keep. We'll see what winds up happening with that. Next slide. All right, so what non-competes are covered? What agreements are we talking about? Traditionally, we talk about non-competes. We're thinking about agreements that say you may not work for a competitor within a certain geographic area doing certain roles for a certain amount of time. And those are absolutely prohibited by the rule. It has to be any term or condition and it's really term or condition of employment, and then employment is defined very broadly as well. I think we're going to get to that issue in a little bit. But it would include, as a consequence of the breadth of the prohibit or penalize or functions to prevent, it brings within the scope potentially non-disclosure agreements, so agreements that you won't, like confidentiality agreements, agreements that you won't use or disclose companies' information, confidential information, non-solicitation agreements, so you won't solicit their customers, or perhaps no recruit agreements, you won't solicit their colleagues, or no business agreements, meaning no service agreements. Those are the kinds of agreements where it's beyond a non-solicitation of customers agreement. It basically is, hey, we don't care who solicits whom, you can't work with the customer, period. So the FTC has identified those as subject to a fact-specific inquiry that is part of their function test, right? If it functions to prevent. So that they can get picked up in that way. And the FTC, it does say that the garden variety NDAs and non-solicitation agreements and all those are generally not going to be considered to violate the rule. But on the other hand, the FTC also keeps for itself the power to prevent those using those types of agreements as unfair methods of competition based on a factual analysis. The rule is not limited to freestanding non-compete. So it's not like when we talk about non-competes, it has to be, here's your non-compete, here's your non-disclosure, here's your non-solicit. This could be a non-compete that is included in any agreement that you might have. And typically, most the way most companies do it, in my experience, is there is a restrictive covenant agreement by whatever terminology it may be called, and it will have all of the different provisions in it. So the FTC is saying, look, we get that. We're only focused on the non-compete part. You don't need to rescind any contracts. That was also under the original notice of proposed rulemaking included that. They walked away from that. Just tell them, as you saw in the notice, just tell them that their non-compete will not be enforced and is not could not be enforced. Next slide. Coming back then to the senior executives, right? That less than 1% of people. The FTC, in part of the rationale for issuing the rule was that it determined that non-compete agreements were exploitive and coercive because they reflect unequal bargaining power. Now, you may agree or disagree with that policy, but that is where they came out on it. But senior executives, they said, look, they're not worried about unequal bargaining power with senior executives. The rationale for regulating non-competes with senior executives is that they are the ones that actually have a greater impact on innovation and on startups and all that kind of thing. And so if you don't let them move, then we're going to have fewer startups and less innovation and all that. And so what the FTC has said is, look, for senior executives, if you have an agreement that is in place as of September 4th, when the effective date, assuming again that that's the day it goes into effect, as of that day, any agreement that exists already can continue to exist. It's not invalidated. You can still enforce it. And that's very different from everybody else where their agreements go away as of September 4th. But again, as I mentioned earlier, CEOs, are the senior executive exemption is very, very, very narrow. It is senior CEOs, presidents, and others with policymaking authority, meaning final policymaking authority, and they have to earn that $151,164. I want to though just identify one interesting development with this rule. So the rule we just saw it, senior executives extraordinarily narrow. Lena Khan, the chair of the FTC, was on CNBC's Squawk Box on April 25, which is 2 days after the FTC issued this rule. And the host, Andrew Sorkin, asked her the following question. I'm going to read it because I think it's really interesting to juxtapose what we just learned about the senior executive exemption to what Lena Khan said on national TV 2 days later. She was asked the following question. I'm going to read it exactly as it was asked. Most people who are on TV have contracts that prevent them. So here we are at CNBC, NBC Universal is the parent company, ABC's just down the street. Literally, Good Morning America is right there, and he points. CBS is just across the street as well. I could not call up my boss today and say, you know what, thank you so much. This has been wonderful. I'm going to walk over there tomorrow. And then he turns back to Lena Khan and says, do you think I should be able to? And she responds, if you have a current contract that reflects the fact that this non-compete is in the contract, your compensation package probably also reflects that. We don't want to disturb that because we realize that for people who are doing very well for themselves, who are well situated to bargain, the contract and the compensation already reflects the value of the non-compete. That is not the senior executive exemption. So how you square her comments there versus the FTC rule is a real problem. And it's unclear to me why she took such an expansive view there in that conversation, because that certainly was a view that had been urged upon her by many people, including some of the people on this call, as something to at least consider, and she rejected it. Next slide, please. I think, David, we're back to you. I think that's right.
Thank you, Russell. And let me just say, we've gotten a lot of great questions. We can't possibly answer all of them, but I'm going to cruise through them just so you know. How long does an employee have to own equity? I don't think the question is about how long you need to own equity to qualify for the sale of business concept. I think it's really going to be, is it a bona fide transfer? You can't just sell someone equity for $1 and then buy it back the next day for $1.01 and think you're going to get a non-compete. There's got to be goodwill. And I think that we can borrow from California law on that. And I think that's what you'll see. Happy to talk about it more in the future. We're going to cover nonprofits in a few slides. Russell already covered confidentiality agreements. If a principal owns a target owns equity through an LLC, I think you can look through, but you're going to need to make the case that it's bona fide and part of bona fide ownership, where when you sell your interest, you're getting fair market value and it's not a sham transaction. This rule applies to workers, not business entities. There are other antitrust considerations for business entities that Ben and I would be happy to talk about on other calls. And I'm going to stop there so we can get to everything else. So we've got these frequently asked questions. And I'm going to turn it over to Carrie to get started on answers to some of these questions and her thoughts on these. And then we'll go from there.
Sure. I think we've covered a little bit of it. Under what circumstances might an NDA or non-solicit rise to the level of a non-compete? Again, it's going to come back to the language that Russell's quoted to you, which is that if it prevents or penalizes a worker from going to another job, then it might rise to the level of a prohibited non-compete. That's going to be a very fact-specific inquiry in any kind of litigation you're in with respect to NDAs and customer non-solicits. But you should certainly guarantee that you should be thinking through those issues if this rule goes into effect, because anytime you attempt to enforce a customer non-solicit going forward, that's going to be the argument your former employee is going to throw on the table, which is, if you enforce this rule, there's no chance I can get another job. Therefore, I'm prohibited and penalized, and therefore it's an invalid non-compete. There are certainly industries where there's only a few customers where you could see that argument really playing. Some of that's going to depend on judges and jurisdictions as well. Same thing with a training repayment agreement. Again, if a worker's going to be able to say, because I have to repay this money and I'm going to work somewhere, that's a penalty to me and it's prohibiting me from leaving. Could that be an invalid non-compete? Potentially. You run those risks again, and those are things you need to start thinking through as you're drafting documents and looking at your agreements, again, with an eye toward whether this rule goes into effect or not. And then, David, I think you were taking over.
Well, actually, can I just jump in just
Yes.
for 1 second on just on that training repayment agreement, which they pejoratively call traps. Well, some people do. What's interesting about the FTC is that they specifically said we're only focused on if the agreement restricts you. This when they were talking more broadly. If the agreement restricts you from working for a particular competitor, we don't care if it imposes penalties on you just for leaving. So if you have forfeiture of stock, for example, that's tied to your departure, regardless of where you go, we don't care about that. But then when it comes to the traps, they take the exact opposite position and they say that, hey, this actually, they may be okay, but if they actually have an impact that prevents you from leaving to go work somewhere, well, now it's potentially a functional non-compete. So it's something that people need to be cognizant of, and exactly as Carrie just said.
And
Right.
Like I said, you just need to be prepared for those arguments coming back to you when you're on the employer side of a non-compete situation, that you're going to be getting any argument that throws that in your face.
Yeah.
Before we move on to the next slides, do any of our panelists have any comments on the other things in this list, or should we just go ahead in the interest of time?
I would just say on this one about, does the rule apply to owners or partners in a business? It's an issue I'm still struggling with, and I think you can point to language in the rulemaking that goes both ways on this. I don't think there's a clear answer. It's a tough one.
All right, so I'm going to go ahead and throw it to the next slide, and Ben.
Thank you. So there was a question on nonprofits, and this goes to, Russell said there's 3 express exceptions within the non-compete rule, but there are a lot of unexpressed or unsaid exceptions. And this comes back to the FTC Act. The FTC Act, Section 5 of the FTC Act, empowers and directs the FTC to prevent persons, partnerships, or corporations from using UMCs or UDAPs. This is the section where UMCs and UDAPs are forbidden, but there are a bunch of carve-outs. So the FTC can't prevent UMCs or UDAPs by banks, federal credit unions, common carriers like phone companies, air carriers, Person subject to the Packers and Stockyards Act, which is a esoteric law for certain meat packers and livestock dealers. So I think of that statue outside the FTC building of the man controlling trade. If that person is a livestock dealer, then that man controlling trade probably isn't subject to the non-compete rule because the FTC doesn't have UMC jurisdiction over that person. But the FTC Act Section 4 defines corporations in a very specific way. Corporation includes any company, trust, yada, yada, which is organized to carry on business for its own profit or that of its members. Next slide. So implicitly, the FTC does not have UMC jurisdiction over a nonprofit or a corporation that is not organized to carry on business for its own profit or that of its members. The FTC, however, has in the past successfully asserted UMC jurisdiction over some nonprofits. They just do so by looking through and saying, you're a nonprofit for federal taxation purposes, but for purposes of the FTC Act, you are organized to carry on business for the profit of your members. So a trade association that itself is a 501c organization, but it represents the financial interests of its members. The FTC's gotten jurisdiction over trade associations, or a physician hospital organization that is a nonprofit itself, but it negotiates managed care contracts on behalf of private for-profit medical practices. The FTC has jurisdiction over that. The FTC is a two-part test. I've got it on there. I won't belabor the point. There is a nuance that you could have, say, not-for-profit hospital system. Maybe a big parent company is a not-for-profit, but that system is chosen to have a for-profit subsidiary that's a medical group that is actually the vehicle for employing physicians. If that employment vehicle is itself a for-profit, then it probably is subject to the rule. And so that's something to keep in mind. And similarly, you could have a not-for-profit hospital that uses a staffing company, a private for-profit staffing company to provide doctors on a locums basis. That for-profit staffing company is almost certainly subject to the rule. So next slide. So what's going to happen next? And I mean, like, immediately in the short term. Next slide. So the FTC voted on a Tuesday to adopt the non-compete rule. The day before, on the Monday, the Chamber of Commerce, U.S. Chamber of Commerce, came out, had a press release or a press conference and said, we're going to file a lawsuit to challenge whatever rule gets adopted tomorrow. We're going to file that lawsuit on Wednesday. So the FTC has its vote on Tuesday afternoon. They voted about 3 o'clock in the afternoon to adopt the non-compete rule. Within about 3.5 hours, a lawsuit was filed by not the Chamber of Commerce, but a private tax services firm called Ryan LLC. They filed a lawsuit in the Northern District of Texas. The next day, as previously announced, the Chamber of Commerce filed its lawsuit, this time in the Eastern District of Texas. And the day after that, a 12-person tree trimming company in Bucks County, Pennsylvania, filed its own lawsuit in the Eastern District of Pennsylvania. For a moment, it looked like the Chamber of Commerce lawsuit was going to be the leading lawsuit and was going to be really the vehicle through which the legality of the non-compete rule was going to be decided. But the court just last week said, I'm the second judge to get this case. The issues are the same. Out of comedy and respect to my fellow federal judge, I'm going to defer to the Ryan case, which is the first filed case. So now the Ryan case, at least as of last Friday, the Ryan case seems to be the leading case. So next slide. There are similar issues in all the cases, but I'll use the Ryan case as the one to describe the primary claim. So the fundamental claim is just the FTC doesn't have the statutory authority to do this. And there's several dimensions of that argument, but that's the first fundamental count. The second is, well, if for sake of argument, the FTC does have the ability to pass substantive UMC rules, then that's an unconstitutional delegation of Congress's legislative powers under Article 1, Section 1 of the U.S. Constitution. Count 3 is another constitutional claim. Count 4, arbitrary and capricious. Count 5, count 6, we'll get to them in a minute. Next slide. The key is this. Count 1, that the FTC doesn't have the jurisdiction to do this. And the Chamber of Commerce has called this an existential issue. This goes to the rule of law in our country. If the FTC can be the second most powerful legislature in the United States, then game over. And so this is the hill that they want to have the battle on. And I'm going to ping pong back and forth real quickly, but looking at the congressional intent and the structure of the FTC Act, there really is a compelling argument that Section 6G, which, I mean, picture there's an A, B, C, D. 6G is just an ancillary provision that's meant to provide procedural powers to the FTC. It wasn't meant to give the FTC the ability to write law. So the argument is that Section 6G only gives procedural powers. And to ping pong to the other side, the FTC's response to that isn't half bad. The FTC can point to a case from 1973 where the DC Circuit specifically considered this argument under the context of that octane rule, which you'll recall was adopted using both the UDAP and UMC power. And the DC Circuit said, well, rules and regulations for purposes of 6G does include substantive rules, not just rules or procedure. So ping-ponging back, the plaintiffs will argue, well, there's never been a standalone UMC rule adopted under Section 6G, or at least never one that's been enforced. And they point to the Magnuson-Moss Act, which was passed after the National Petroleum Refiners case, which restricted UDAP rules. But to ping pong back again to the FTC response, they're going to point to the Mag-Moss law and say, yeah, but Mag-Moss made an exception for rules with respect to UMCs. Next slide. So the plaintiffs had plenty of arguments in response to that, not least of which is that the National Petroleum Refiners case actually makes really clear that the FTC's regulatory authority is not absolute and the commission is hardly free to write its own law. They could say that exception in the Mag-Moss Act, it would be anomalous to interpret that to say, okay, well, the FTC could adopt the octane rule based on its UMC powers, but not its UDAP powers. That would be an odd result. But it's an issue. And, really what the plaintiffs want to do is overturn the National Petroleum Refiners case. So it'll be interesting to watch. Next slide. Where this could very well go, and I think the most fundamental criticism of the non-compete rule is the major questions doctrine, which is something that over the past 3 years, the Supreme Court has repeatedly invoked to invalidate major rulemakings in areas of real difficult policy decisions, like regulating carbon emissions under the Clean Air Act or student loan repayments. And the Supreme Court said, Congress doesn't hide elephants in mouse holes. If Congress is delegating to an agency the power to make real major substantive laws, that has to be a very, very clear delegation. And the court has articulated 3 factors, and I won't read them aloud, but the plaintiffs are going to be able to say, check, check, check. This shoe fits. This is a major questions doctrine case. The fact that the Congress is not clearly delegated to the FTC the power to pass a law on non-competes means that this was not a delegation to the FTC. This could be where it goes, but there are other claims, as I noted. So next slide, I'll quickly touch on the other claims. One is that the delegation to the FTC was to prevent unfair methods of competition. And there is a Supreme Court case, granted it's a case from 1935, but a Supreme Court case where the Supreme Court said unfairness is not enough of an intelligible principle to delegate policy-making authority to an agency. That is unconstitutional because policy decisions have to be made by a politically accountable Congress. Another claim is that the whole FTC is unconstitutional because the president can't remove commissioners except for cause. And under Article 2 of the Constitution, the executive power shall be vested in the president. The president should be able to remove inferior officers. Now, this argument has been litigated in the Fifth Circuit as recently as 5 months ago, and the Fifth Circuit ruled for the FTC. So the claims for it closed, but they're setting up a potential Supreme Court case. Another claim, which is a really interesting one, we've spent a whole hour on this, is even if the FTC has rulemaking authority, that doesn't allow it to ban contracts retroactively. It becomes a takings clause, a Fifth Amendment issue. Pretty interesting argument. And then the last one is just, this is an arbitrary and capricious rulemaking. They failed to weigh the evidence or consider all comments, and they failed to properly conduct a cost-benefit analysis. So it'll be really, really interesting to watch, but there are a lot of issues to unpack.
So where do we go from here? Next slide. So as Ben indicated, the Ryan case is the one that seems to be moving forward because the case in Tyler has been stayed pending at least what's going on here. The Ryan case is in the Northern District of Texas. It's in front of Judge Ada Brown. She was appointed by Donald Trump in 2019. Obviously, take that for whatever political issues you may take from it. They've effectively moved to stay the effective date and have a preliminary injunction against the rule. And the courts put to a pretty onerous briefing schedule. They've already filed their motion to stay. The FTC has until the 22nd of this month to file an opposition. Ryan has until June 5th to file their reply. If the court's going to hold a hearing, it will be on June 17th. Court is reserving judgment on that until it gets a chance to see the briefing that happens, and then says it will issue its decision by July 3rd. That's a pretty aggressive ruling date, if you will, based on where we usually see courts come down. So hopefully that's what will happen. So we'll all have some understanding of where we're going next. Next slide. So, I mean, there's, three options here. One is that the court invalidates the rule, in which case we go back to the status quo while the FTC likely appeals the decision to the Fifth Circuit, but it would stay the effective date that's now for September 4th. The court could uphold the rule in its entirety, in which case effectively non-competes will go away. Again, presuming that Ryan will appeal it, then we'll have to decide what happens to other cases based on this issue. And then the court could invalidate some part of the rule, and we'll have lots of other courts deciding these issues, and we'll have chaos. Next slide. And then everyone feel free to join in. Where are we going from here? I think we've all agreed that, our most likely outcome is scenario one, which is that we all think the rule is going to be invalidated just on a whole host of reasons, some of which we couldn't get into today, but obviously can't rule out scenarios 2 and 3. If the rule survives in some part, you need to be prepared for what that looks like. Again, we have some time because in theory, we're getting a ruling on July 3rd. So you'll have some time to make these kinds of decisions, but be prepared to start gathering, if some part of the rule survives, who you have that are subject to non-compete so that we can get the required notices out to them. That's not something that can likely be done overnight. Meaning you're going to have to get addresses, emails, phone numbers, identify, where those non-competes are, who's subject to them, and then start looking at, do I have senior executives who should be subject to non-competes? Meaning if I get it done before the rule's effective date, you may want to make sure whatever you've done is, as buttoned up as you want it to be, meaning we may want to go back and look at our current non-competes with who fits in that definition of senior executive and move forward with a revised non-compete that we feel more comfortable with, because we're not going to be able to, in theory, enter into them after the rule's effective date if some part of it remains in place. Next slide. David, I think you're taking over.
Okay, great. Thank you. So we are at slide 38. And I guess one of the things I want to say or talk about is what do we need to do next year? And if, obviously those of us on this panel will be spending July 4th reading whatever the decision is, while the rest of you all are hopefully having fireworks, going to Dairy Queen, having blizzards, all that sort of fun stuff that makes July 4th so much fun. We'll know July 4th, but depending on what happens there, that's when the real work's going to begin. Either it's going to be a nothing burger and the thing is stayed until it gets through litigation, which will take years. If it's not stayed, then some of the best suggestions we have are reviewing your non-disclosure agreements, your non-solicits that don't rise to the level of non-compete, your fixed duration employment agreements, and other ways to incentivize employees. Generally, that means bonuses, commissions, things like that are financially based or benefits based and not, negative covenants about non-competition. What does that mean in reality? What it means is the more likely weapon at your disposal is going to be confidential information and trade secret remedies. Those are more expensive. Those require imaging hard drives. Those require having technologists either in your organization or a contract with with folks who do that, who every time an employee leaves, you're going to want to change your protocol to make sure you're locking down their hard drives, all their hard drives. You're going to want to be able to see what they send to their phone. You're going to want to be able to see what they send to their personal Gmail address. Those are the most likely things all of us see in doing this when an employee leaves and they take information. And frankly, a lot of companies, they'll tell you when someone accessed something, they can't tell you whether the jump drive has been inserted, whether it's been printed, whether it's been downloaded or emailed. Those things are knowable. That metadata is knowable. And I think all of us are going to have to adjust to this world where we can show and prove that. So I've got 1 minute left. So before I open it to any last thoughts, let me just say, I know several of you had questions we couldn't get to. I apologize. We apologize. Feel free to follow up with us afterwards with your questions. We are happy to answer them. Anyone else for the good of the order?
Trade secret protection program, just to your point, David, just highlighting your point. Trade secret protection program is going to be key now.
Signing out lab notebooks, restricting access only to people who need it. You know, for instance, if you have a salesperson that's working in 2 states, they should not, under any circumstances, be able to access sales reports of anyone else in other states who they do not oversee. And yes, we will send the slides out. Stay tuned for follow-up on that. Thank you, everyone. I'm going to go have a late lunch.
Thank you.
Thank you.
Thank you.